Good afternoon, everyone, and welcome to today's CCPL seminar. Brings me great pleasure to welcome Dr. Claire Smyth, who is an associate professor at Kingston University, where she teaches in the area of international law, human rights, but also trust and equity. But she's been investigating and I believe is working on a book in relation to socioeconomic rights and has been studying closely the jurisprudence of the European Court of Human Rights. And of course, here in Hong Kong, we know that that jurisprudence is of great relevance to the development of our own jurisprudence. And today, Dr. Smyth is going to be talking about issues of justiciability, which is, of course, another area that we are very much interested in to see how the international covenant, the ICESCR, might be invoked more in our jurisprudence. So Dr. Smyth, thank you very much for being here.
Thanks to Professor Young for inviting me in the centre and to all of you for coming here to listen today. As Professor Young said, I am going to talk about social and economic rights in terms of justiciability, particularly today. I am working on things at the moment in relation to the ECHR specifically, but that doesn't necessarily form a huge part of what I'm going to talk about today. Social and economic rights, as you know, is a huge, vast area, and I've got 45 minutes to speak to you. So I'm going to try and keep it to 45 minutes. May not be able to get through everything because it's such a big area, because I tend to get sidetracked, and also because I'm Irish and we're well known for talking way more than we should. So a little bit of history to start as to where socioeconomic rights sit in the international order as it stands. So a new international order for human rights as we know them today came out of World War II. So the UN was created, and within that General Assemblies, one of their main jobs to do was to protect human rights. In 1948, the Universal Declaration of Human Rights was signed, and within the UDHR, all rights sat side by side. There was no distinction made between whether a right was civil and political or whether it was socioeconomic. They all sat there together. The problem with the UDHR, of course, was that it was not a legally binding document. And so when negotiations started to make this document a legally binding document, quite a lot of deep discord came about in those discussions. And you can see how difficult that was, because in 1948, the UDHR was entered into. 1949, discussions started about transposing this document into one that was going to be legally binding as opposed to one that was just aspirational in nature. It wasn't until 1966 that the two UN treaties actually came into force. So you can see almost 20 years of discussions happening around this. Now, a really deep divide came as to the status of social and economic rights. Where should they be put? Should everything go into the same treaty and everything be given the same legal force or not? One of the main reasons that authors talk about as the reason for this divide is the kind of capitalist communist divide within the UN, particularly the Cold War era between America and Russia. And that's one of the things that people say is the driving force between that. But one of the reasons this was successful was because of the support that Europe and European nations gave to the American side. This has sort of been put out as saying, well, Europe subscribes to this capital ideology as opposed to a communist ideology. That's not really the full picture. Stephen Jensen writes a lot about this, where he talks about the legacy of colonialism and why Europe was so keen to support America in this. The reason being that at that stage, 1940s, 1950s, a lot of European nations still had colonies in various parts of the world. If these rights are to become justiciable, not only do they have to afford those rights to the people within their jurisdiction, but also within the colonies and the territories that they oversaw as well. So colonialization and that legacy is also one of the reasons why we have this divide in international law. So within this, within these discussions, eventually what happened was the two sets of rights were split. You've civil and political rights put into the ICCPR, social and economic rights go into the ICESCR. And these two treaties are very, very different in how they're worded. So in the ICCPR, it's worded very strongly. It says everyone has the right to. It's very strong in its wording. Whereas social and economic rights are to be realized progressively, subject to available resources, a much more watered down approach. So you can see on that level that the wording that's afforded to both of those sets of rights says to the outsider looking in, civil and political rights are clearly much more important than socioeconomic rights. In addition to this, the Human Rights Committee was able to hear individual complaints for violations of the ICCPR. The same was not afforded to social and economic rights. So why is this an issue? What are the arguments against justiciability? First of all, are they rights at all? Are socioeconomic rights rights as we would classically understand them? Most of the literature today says, yes, that's been decided. We agree that they are rights. I would disagree with that. And I disagree with that because if you take a legalization approach to rights, it basically says that you can't classify something as a right unless it can be justiciable, unless you can enforce it in a court. You can't classify this as a right. So I'm not so certain that this overarching debate has actually been solved, and we have conclusively decided that socioeconomic rights are rights. Do I believe they are rights? Absolutely, I do. But in the international and the grander scheme of things, do states believe that? I don't think so. The other more common arguments now. So first of all, characterization. There are two sets to this. And these are all reasons that in various states, either courts or governments have put forward as to why these rights are non-justiciable. So first of all, they'd say, well, the content of the right is vague. And because the content of the right is vague, then we can't have it as justiciable because we don't quite know what it is that we're going to be adjudicating upon. I would say that that doesn't hold water, because if we look, for example, at the right to life, our most classic civil and political right, the treaty will just say everyone has the right to life. It is through court cases, through adjudications, that the parameters of that right to life have been defined, what it includes, what it entails, positive and negative obligations on the state. So that's not really a good enough argument in my view. The second one is that socioeconomic rights have this, have the notion that they are necessarily going to be expensive, that there are positive obligations and it's going to cost the state a lot of money in order to enforce these rights. There are two arguments to this. One, all rights are necessarily expensive. If any of you were at Dr. Ed Johnston's talk yesterday, he was talking about issues of disclosure, right to a fair trial, due process. They are classic civil and political rights. They're costly. You have to ensure legal aid, you have to ensure access to courts, etc. So all rights are going to necessarily entail access to funding. Secondly, though, you can also adequately, in some occasions, protect these rights in negative measures. So you could say, for example, while we're not going to say we're going to provide housing for everybody, we are going to stop arbitrary evictions. So that's a negative obligation, and they can sometimes be protected in that way. So this argument doesn't really work. The next argument is capacity. The argument here is that judges don't have the capacity to adjudicate on these kind of cases because it would necessarily involve the judge being involved in subjective views of maybe what poverty is and how would they come to a decision, and that these cases necessarily have such polycentric considerations that it would be impossible for the judges to make this determination. Now, the answer to that again is quite simple. We don't expect judges to be experts in everything. We can have cases involving complex aviation or maritime law that a judge may not be experienced in. What we do in those circumstances is we bring in an independent expert who will give their evidence. The same can be said for that. You're not expected to be an expert on everything. The final argument is democratic legitimacy. This is the one that has come up in the courts more often than not. The argument here necessarily involves the separation of powers. So it says that because these rights involve spending money, that these decisions remain and should remain within the purview of the government who decides how to spend its money, not the courts telling the state how to spend its money. This is the most persuasive argument that the courts have put forward, but again, I don't think it's a legitimate argument. Firstly, courts tell governments how to spend their money all the time. If one of your civil and political rights are violated, you can get compensation as a result of this. So they are telling the state how to spend their money. Secondly, if you put a whole category of rights within the purview of the executive and say, we're not going to adjudicate on these, what this is doing is it's creating a situation that the separation of powers was designed to prevent against. Separation of powers is there for a checks and balances system. If you take them all out and say the judiciary is just not going to look at these, they sit over here, that's creating all of the power in one arm of the state for the protection of these rights, which undermines the entire argument. So that's a brief overview of the reasons why, or the arguments made against justiciability, which, as you can see, when you interrogate them a little bit more, they don't actually make very much sense. So a move towards justiciability came in international law from about the early 1990s, when the Committee for the International Covenant on Social and Economic Rights started calling for the introduction of this optional protocol. The optional protocol was to allow the committee to hear individual complaints. Up until this stage, it couldn't. Its only role and responsibility was to engage with the periodic review, which was not always very successful in terms of its recommendations and in terms of state engagement and the various issues being brought properly to the committee. When this started, again, the same arguments against justiciability started to come up. So these are not new, they're still ongoing, and they've been around for a very long time. It was only in 2013 that that protocol actually came into effect, which established the individual complaints mechanism. This ought to have been a really, really good thing, and it was very exciting for some people like me who were working on this research at the time, and we were thinking about how powerful this optional protocol could be. Unfortunately, hasn't really turned out to be so. Firstly, the optional protocol did nothing to change the wording of the treaty itself, of the ICESCR. So we still have this notion of the rights having to be progressively realized subject to available resources. The committee has watered down quite a lot of aspects in it as well. So one of the main aspects in the treaty is that you can't have regressive measures. Well, with austerity and all the measures that came in from austerity, they said, well, you kind of can have regressive measures, but you have to bring them back very quickly afterwards, although that didn't necessarily happen. The optional protocol itself is worded quite weakly. There are quite extensive admissibility criteria, first of all, as well, to have your case heard before the committee. You have to exhaust all domestic remedies, first of all, which is pretty standard in all kinds of international or regional treaties. The problem, however, is that a lot of states don't actually have a forum for bringing to court social and economic rights cases. So you can't exhaust domestic remedies, or it's very difficult to try and do this. The case has to be brought within a year of exhausting the domestic remedies, which is quite a short time frame. Initially, they wanted it to be 6 months, but there was a lot of pushback from NGOs that said that that was simply too short of a time frame. So it's now a year. They wouldn't agree to a reasonable time period being put in, that phrasing of a reasonable time period. So it's now a year. But there is some leeway that the committee has, that it can accept cases beyond that where there is a particular reason that the complainant couldn't take their case before that. What is new in this international treaty is that one of the admissibility criteria is that the individual has to show that they were manifestly disadvantaged. So it has to be that whatever is going on in that state, that the violation has manifestly disadvantaged that particular individual over and above all other individuals within that state. So it's quite a significant step, and that particular admissibility criteria is not in any of the other UN treaties. The next thing is that the committee can take into account reasonable steps that the state has made. It doesn't define what reasonable is. And it seems from the cases that have come before the committee so far, that once the state has taken some steps, because remember, we're not talking about a concrete obligation, we're talking about progressive realization. So once some steps have been taken, it seems that that reasonableness test will be met. Another issue, obviously, is in terms of enforcement and sanction powers. The committee does not have the power to sanction. It can ask for interim measures to be put in place. It can make recommendations, much like the European Social Charter, but it can only give considerations. It can't give reparations. So to have a look at the cases that have come before the committee so far. Remember, this came into effect in 2013. So we're looking at nearly 10 years on. There's been 114 cases that have gone before the committee. Of those cases, only 9 have had a decision on the merits of the case. So overwhelmingly, the cases that are coming before the committee are being found to be inadmissible for a variety of different reasons. Out of those 9 cases, there have been 7 violations. So it seems by looking at that, that while it's very, very, very difficult to get your case heard before the committee, if you do get your case heard by the committee, you have a good chance of having a finding of a violation. But the threshold to get there is so high that it makes it very difficult to have it heard. Of those 114 cases, all but 30 have related to the right to housing. And more interestingly, out of the current 196 cases that are pending before the committee, all but 4 relate to housing rights. So the vast majority of the work of the committee, of the cases that are coming before this, are looking at housing rights. And so on the basis of that, I want to kind of focus the rest of this on looking at the right to housing, and that being clearly a human rights crisis. Interestingly, the vast majority of cases that have been taken so far to the committee have been taken against Spain, which is quite surprising. You wouldn't think that it would be a Spanish jurisdiction that was having the most cases against them for violating the right to housing. So when we're looking at the right to housing, it's a very multifaceted and complex area. It looks at issues involving evictions, homelessness, rent controls, adequate standards of living, a whole host of different things, interest rates, mortgages. It's very, very complex. And I don't have time to go into all of those various different aspects. So I'm going to focus on the issue of homelessness as being the kind of big one at the moment. Just looking at the world population reviews, we're looking at an estimated 180 million people being homeless around the globe. Hong Kong is at the lower end, with apparently 1,800 people being registered as homeless. The UK having 400,000, close to 500,000. These statistics are problematic because they take into account only people who are actually registered as being homeless. It doesn't take into account people who are living in cramped, overcrowded, unsanitary, inadequate housing conditions. It doesn't take into account people who are what's called couch surfing, who are going from staying with one person to another to another. It doesn't take into account people in temporary accommodation where they're being housed in B&Bs or places like that. So the actual figures are quite a bit higher. So when you look even at the issue with Hong Kong and you look at these statistics that say, okay, only 1,800 people are homeless, but then you do some of the reading around what's happening in terms of the cage houses and coffin houses and various, these people are not classed as homeless, so they don't fall within these statistics, which makes it quite difficult. This issue has as with all socioeconomic rights, it has a knock-on effect for everything else. If you're homeless or you're living in very unsanitary, inadequate conditions, it's going to impact on your right to health. It's going to impact on your right to education. It's going to impact on employment, etc. It's not just one standalone issue. All of these socioeconomic rights interlink and interplay together, and they have a massive impact on your ability to engage with civil and political rights. And it's something that is it's always confounded me a little bit in relation to this, because if you are homeless, if you're hungry, if you're sick, you're not considering how you can engage in political life. You're not concerned about voting. You're concerned about how you're going to feed your children. You're not concerned about what's going on politically. You're concerned about where you're going to sleep tonight. So without the vindication of socioeconomic rights, civil and political rights cannot be realized. And so it's always been one of those unfathomable things that why would these precursors to life not be given primary consideration over these civil and political rights? So how have the courts responded to this issue? In international law, the situation effectively is the rights are split. They're in two separate categories, and it's quite clear that social and economic rights are subordinate to civil and political rights. They are not seen as the same, despite kind of official statements that they're indivisible and interdependent. It's quite clear that they are ascribed different importance when it comes to how the treaties are worded and how they're being enforced. As a result of this, the courts have kind of been left to, in different jurisdictions, to their own determinations as to how they're going to go about this. Yes, there are minimum core rights in international law that they're supposed to impose, but without any enforceability or sanctions, it's very difficult for that to actually be imposed. Within the European region, the ECHR has looked at some of these cases as well. And Simon mentioned that the jurisprudence of the ECHR is something that you guys look at quite a lot, and it's quite important. Within Europe, the same divide that happened on the international scale happened within the Council of Europe as well. So in the 1950s, early 1950s, Europe decided that it also needed to have a regional response to what happened in World War II. and the Council of Europe created effectively the body that would protect human rights. So we were split into two. You had the European, what is now the European Union, that was looking after the political and monetary stabilization of the region, and the Council of Europe that would look after the human rights implementation. Again, we have the same split in rights in the Council of Europe that happened on the international stage. You have the ECHR, which protects civil and political rights, and you have the European Social Charter, which protects the socio-economic rights. And again, the differences between the two are quite stark. For example, again, there is no individual right of petition to the European Social Charter. It's a collective petition that needs to be made. States don't opt out, don't enter derogations to the European Social Charter. They sign up to minimum rights. They decide which rights they want to sign up to. So you can see within the European setting that this same divide happened. The ECHR, though, has become more and more activist in bringing in socioeconomic rights, reading them into the civil and political rights, where they can see that the violation of the socioeconomic rights is such that it impacts on a civil and political right. It has done this to varying degrees of success, and it has looked at cases of the European Social Charter. It's also looked at international law to make these determinations. And it kind of follows in a way the Inter-American Court of Human Rights that has also done pretty much the same thing. The American Declaration on Human Rights does not contain socioeconomic rights, but the Protocol of San Salvador, which is non-justiciable, does, and the Inter-American Court has read it into the civil and political rights. So essentially what's happened through the case law, and I'm just mainly kind of focusing on, again, on housing issues, is that predominantly when it comes to housing issues, the ECHR has said there is no general right to housing. There is no positive obligation to be housed. However, if you are particularly vulnerable, then that positive obligation may be imposed. The Yordanova and Bulgaria case, this was about a group of people who were of Roma descent, and they had built kind of makeshift houses on municipal land. That was then decided, there was an order from the state to get rid of these, which the court upheld and said they could be demolished. It went to the European Court of Human Rights. The Court of Human Rights said that it did engage Article 8 because they found it was a home under the terms of Article 8, despite the fact that it was temporary shelter, it was quite makeshift, and the state couldn't evict them because of their particular vulnerability being in the Roma community and the fact that there was no alternative accommodation being offered to these people. So again, it's not saying there's a positive obligation to provide housing, but where people have created shelter, you cannot take that away from them unless you are going to provide something different. Generally speaking, it falls within the margin of appreciation of the state as to what those positive obligations are going to be. Where it has had significant impact is around evictions. And these encompass evictions from social tenants, private tenants, and quite a lot of cases involving members of the traveller community or the Roma community who would be living in kind of makeshift camps on state land. And essentially, what that has done is it said that there has to be a proper eviction procedure in place that must be followed. That procedure has to be proportionate to a legitimate aim, and regard must be had to the particular facts of the individual case. So we have to have a procedure that's in place. It's not saying you cannot ever evict people. It's saying that where you are going to evict people, you need to have a procedure in place for doing this that is a lawful and proportionate procedure. There has been some moves towards introducing more positive obligations on the state. The Suarez de Mello case involves housing, but it also involves other aspects. So in Suarez de Mello, there is a mother who is a single parent. She's living with a number of children, and she's living in very, very poverty-stricken conditions. Her children are not being fed properly. Her housing is very poor. It's unsanitary. It's damp. Electricity and heating keep being turned off. Children aren't going to school, etc., etc. What happens in this case is Portugal take the children from her. She makes a complaint about this. It obviously goes all the way up to the courts in Portugal and then goes to the European Convention on Human Rights. And the European Convention on Human Rights found in favor of the complainant here for a violation of Article 8 rights. And this is where it imposed the positive obligations. It said you knew of the circumstances in which the complainant was living. You knew of these conditions and you did nothing to assist. So where you are aware of these conditions and you've done nothing to assist, this is going to invoke the positive obligations. So this case really sets up this idea of an awareness on the state, that if the state is aware of the particular issues of this particular individual and it does nothing to step in and help, that can be a violation of Article 8 of the Convention. I think I've got just about enough time to go through some various different jurisdictions. So in terms of domestic jurisdictions, then, there are kind of 4 areas that I just want to briefly look at to kind of give you some comparison as to how domestic courts have incorporated these rights. South Africa, one of the newest constitutions that came in the late 90s, incorporates socioeconomic rights directly into their constitution. They are written rights side by side with civil and political rights. How are they going to interpret those rights was the big question when it came to the adjudication of these cases. I don't know if that's me or not. So in Grootboom, that was the first case that looked at the right to housing under the South African Constitution. Grootboom involved a huge amount of temporary settlements, again on government land. There was a push to try and move people off that land. The case was a public interest litigation case that said Section 26 of the Constitution provides the right to housing. This needs to be vindicated, and it's not being vindicated in this case. What this case turned on was the fact that there were children, and so many children being involved in it. And the rights of children to housing is specifically contained in the Constitution as well, under Section 27. And in this case, they found that moving them off this land was a violation of the right to housing. But the decision fell short. So it only granted declaratory orders rather than mandatory orders. So there was no positive obligation put on the state to rectify this situation, just a declaration that what it was doing was wrong. It also didn't say what would satisfy this concept of reasonableness. So how could we say if the state has taken reasonable measures or not? It didn't clarify what that was. And subsequent cases that have come after this that don't necessarily involve the right to housing have been relatively disappointing in terms of how the South African Constitutional Court has dealt with socioeconomic rights. So if you're interested in looking at additional cases on South African jurisprudence, you could look at cases like Subramani, Matsibuku, and the Treatment Action Campaign that are really instructive as to how the court is interpreting these. I'm going to come back to India in a second, but I'm going to skip on to Ireland because the Indian constitution was based on the Irish constitution. So I just want to start with that first. The Irish constitution, Bunreacht na hÉireann, was came into force in 1937. It's a relatively old document. There are a list of fundamental rights that are contained within the constitution, all with the exception of education, are civil and political rights. Article 45 of the Constitution is what's called the Directive Principles of Social Policy. And that is explicitly a non-justiciable clause, which says the state shall strive to provide all of these socioeconomic rights, but it doesn't place a legal obligation on the state to do so. It's explicitly non-justiciable. Several cases have tried to bring this article in to make it justiciable. TD and the Minister for Education is the core case in Ireland in 2001, which says categorically social and economic rights are non-justiciable. They are set within the government. There's no place for the courts to deal with them. A very harsh case indeed. But O'Donnell and South Dublin County Council, this does involve the right to housing. And this was brought as a result of poor housing conditions from members of the travelling community who were living in very dilapidated halting sites at the time. They sought an argument that the right to housing, A, was contained within the Constitution, which was shut down. But they did, so the European Convention on Human Rights is incorporated into Irish law under the 2003 Act. And they did find a breach of Article 8. So in Ireland, even where you can't get socioeconomic vindication through the Constitution, there is potentially a route through the ECHR. And that's an illustration of how the ECHR can work in relation to this. So in that case, it was interesting. They didn't award a new house. They didn't award, it wasn't a house they were living in, it was a caravan. They didn't award a new place to live for those people. They didn't order that the state provide this. They awarded damages, which just happened to be the same amount of money as it would cost to buy this new caravan that would adequately accommodate them. So kind of a roundabout way of getting the vindication. But going back to India, as I said, the Indian constitution was modeled on the Irish constitution. And their Article 21 Directive Principles of Social Policy was directly taken from the Irish Constitution one. So it was thought that the Indian courts would take the same path as the Irish courts in doing so. The Indian courts have gone the furthest in vindicating social and economic rights. The main case involving housing is the Olga Tellis case, which is again a public interest litigation case involving pavement dwellers. And the city was trying to clean up, get rid of all these pavement dwellers, move them to a place quite far away. And it was argued that this would infringe their right to life, because it would infringe their right to earn a livelihood. They worked and lived on these pavements. And the court in this case said it would be sheer pedantry to exclude the right to livelihood from the content of the right to life. What India has done is it has taken the right to life and it has interpreted it in a very expansive manner. And while it doesn't involve housing, I'm just going to tell you a tiny little bit about what India has done, because it's fascinating. The Indian courts have decided to, in some cases, not even wait for a complainant. They have taken cases on their own motion. So there's one case the court on its own motion took in relation to, there was a woman who died on the side of the road after giving birth, a homeless woman. And the court heard about this, took a case itself against the state. And it was the first case in the world to recognize preventable maternal death as a violation of rights. So they have really come a long way. In the in another case, the PULC case, they have imposed significant sanctions against individuals, not just the state, where they are holding individual council members, executives, liable effectively for breaching the orders of the court. So India has taken the complete opposite direction to what Ireland has taken. Finally, Canada. We've got about 2 minutes left. Canada, again, doesn't have a written constitution as such, and it doesn't provide anything explicitly for socioeconomic rights. Section 7 of the Charter that looks at equality issues has been used, Section 7 and Section 15 have been used quite a lot to bring in social and economic rights. And one of the key cases is Victoria City and Adams, which again looks at the protection of social and economic rights, but through a negative obligation. So here again, you're looking at issues of public shelters being erected in parks. City wants to get rid of them. It goes to court. The court says, we're not going to tell you that you have to provide shelters for all of these homeless people, but where they have provided shelter for themselves, you cannot just take that away. So it's a negative obligation. A very interesting aspect, doesn't involve the right to housing, but I would encourage you to look it up, is the Insight case, which looks at the right to health and how Canada has protected the right to health through this particular case. So in my last minute, will justiciability solve the issues? No, but maybe. It's a difficult one to address. You can't quite say yes or no. I am a staunch advocate for justiciability. Is that justiciability going to solve all the issues? It's not. The issue with socioeconomic rights is that they are political in as much as they are legal. So it's not always just about having that legal response. However, until we have a situation where social and economic rights are given the same legal status and are recognized the same as civil and political rights, until they are taken seriously on the same level, then we're never going to get anywhere with them. There is a lot of work being done in countries and grassroots movements, NGOs, charities, etc. It's not enough. They have to be taken seriously in this legal sphere as well. Is it going to solve all of the issues? No, but it's definitely a step in the right direction. It's kind of like saying, there are no violations of civil and political rights now. Of course there are, but we can go to court and we can have them vindicated. We can't do that with social and economic rights. So until we can do that, we are not going to get to the core of vindicating these rights. So no, but maybe on the right direction. That's it. I'm just on time. Thank you, everyone.
Well, thank you so much, Dr. Smyth. This is a very fascinating area, and just how you have covered this topic from so many different angles. And there's no sort of one direct way of looking at these cases. I think it's really, really interesting. Am I correct that you said that there were 7 violations under the optional protocol cases? Did you talk about any particular one today? Yeah, is there any reason for that? I'm just curious.
They involved just to give you an overview of what those cases are, they primarily involved the right to housing. Yeah. They were against Spain. Yeah. They were generally about evictions. Okay. And people being evicted, which is it seems to be a vast majority of the work of the committee at the moment. So
evictions of private tenants. So these would be disputes between private landlord and private tenant. Is that correct? And social, okay, so that's where the state gets implicated. I see.
So it's not just about, you know, the state evicting, but it's where somebody is going to be made homeless, the obligation on the state then to provide somewhere else for them to stay, particularly where there are children involved.
Very good. Well, thank you so much. Lots of food for thought. I know lots of litigators in the room. Hopefully it's stimulated some ideas. This has been most enjoyable, and I'm sure we could go on further, but we've got to end here. And let me thank you very much on behalf of the faculty and the center for sharing your presentation today. Please join me in thanking Dr. Smyth.